Hello students, welcome to PW OnlyIAS. I'm your head Preet Singh with the daily analysis of the Hindu from 4th of October 2024. Let's begin with today's analysis. Firstly, this is a Telegram account where you can find this particular PDF along with it the various articles that are posted here which are useful for your preparation. Let's see what are the various news that we have taken for today's consideration. Let's begin. First is PM Internship Scheme. Next is Periyar Ramaswamy Naikar, the topic of marital rape, and the editorial that deals with the university ranking and the various issues that are concerning that. Let's begin with the analysis. Okay, the first and an important article that came is internship scheme that has been announced by the government of India. Now let us see what this internship scheme basically is. Who all are eligible? Now this question can be asked in your preliminary examination, because what they can do is they can give you certain statements and tell which among the following is correct with respect to this internship scheme. Let's see. First, PM internship scheme. The scheme will enhance the youth employability in India by offering them hands-on exposure to the real world business environment. So that means this is a way in which students, aspirants can basically get an exposure to the industry. What are the requirements and needs of the industry? So this is a positive way ahead, by which the employability, that means the capacity of being employed, is what is being tested and enhanced and being skilled over here. So this is the major aspect of this particular scheme. Let's move ahead and see. A monthly stipend of 4,500 rupees will be provided to the interns via the central government via direct benefit transfer. That means directly transfer to their accounts. During this particular internship period, every month, a particular candidate would be given a monthly stipend of 4,500 rupees. Along with it, an additional rupees 500 would be provided by the company's CSR fund, where the particular aspirant or a person is being working as an intern. That means that comes out to close to comes out to be 5,000 rupees. 4,500 from the central government and 500 from the company where the person is basically an intern. So that means 4,500 plus 500 is 5,000 rupees. Let's move ahead and see who is eligible. Now there is a criteria basis on which a person can basically apply for this internship scheme. One has to be very careful whether one is eligible or not. Please understand. The candidates aged between 21 to 24 years who are not engaged in full-time employment are eligible. That means if you are 25 years, 26 years old, or you're 20 or 19 years old, you are not eligible. And secondly, along with it, if you are not engaged in any full-time employment, only then you can basically register yourself to these internships. Those who have passed class 10th or higher are eligible. Now that means if you, let us assume you haven't even passed class 5, that means you will be ineligible. So basic criteria again is who have passed class 10th or higher will be eligible. Individuals from families with government jobs are excluded. That means if your father or mother has been a government employee, you are excluded from this internship scheme that is basically being offered by the central government. Next, candidates who graduated from premier institutes like IIT, IIM, IISER, and those who are CAs or CMA qualification would not be eligible. That means if you're passed from IIT, IIM, other premier institutes, or you are having, let us say, you're a chartered accountant, you will be ineligible for these particular internship schemes. It is not open to family members who are eligible for the income tax assessees. That means if you're paying the income tax, then again you will be ineligible. So again, within the income tax bracket, if you're coming, you will not be eligible. So these are certain ifs and buts that one has to be careful while you are applying for this internship scheme. Now please note down that very carefully, that in your preliminary examination, they can very well ask any of these eligibility as statements, and then they can test you which among the following statements is or are correct. So that means you need to know these statements properly. Right now, what are the benefits of this internship scheme that has been launched by the central government? See, on-job training is being provided because you'll be working in some private companies, let us say. Exposure to the real life environment, pipeline of the skilled workers, post-internship employment options are available. Now, these are certain benefits. Now, please remember, there are certain issues also. The issues are, this internship is basically for 1 year. Within 1 year, will as the person who is going to for the internship will be in a condition that he will be perfectly skilled for the let us say on-job demand of the industry? Yes or no? That raises a question. Second is that the eligibility criteria says class 10th and above. Now, assumably, a person has passed class 10th and dropped out from class 11th. Now he wants to apply to one of the top companies as intern. Will that particular company take that particular person as intern or not? Thirdly is that the supply, that means the people who are going to apply for this internship is going to be a humongous number. But are there positions, or let us say availability of those many interns in those particular companies? Yes or no? Then that also raises a lot of issue. Now along with it, we generally said exposure to real life environment. Yes, that is a benefit, but we realize that skilling itself is something that takes some time, not merely 1 year. So again, this can pose a challenge to these particular schemes. So we have to be very careful that after some time, when the pilot projects are carried out, we can see what are the various impacts of this internship scheme. To begin with, it is a positive way ahead. Basically, it will enhance the interaction of the industry with the people that was currently missing right now. This is the first article that we discussed. Let's move ahead. Next is decks cleared for Perar Memorial in Alappuzha. Now, please understand the article on Ramaswamy Naikar, or Periyar, which very lovingly called also, has been in news repeatedly. Even in today's newspaper, it was mentioned in 2 different articles. I've taken just one. In 2 different articles, the name of Periyar came. Now, for us, it is important that because repeatedly the name of one prominent person comes in the newspaper, it becomes important for your prelims as well as your mains examination. Now, see, the name is Erode Venkatappa Ramaswamy. Now, let us deal and study something about what his life has been and what contributions or what thought process he had. And we should have a brief knowledge also about him because it can be asked in your exams. See, he was born on 17th of September 1879 in a Kannada-speaking family in Erode. He was a social activist and a politician. He is also known as the father of modern Tamil Nadu. And he died in on December 24th, 1973. So, led a long life, was a person who worked for the rights of the downtrodden, the depressed classes, and played a very important role with respect to the social justice and social justice movements during the freedom struggle also. Now, have a look at what all or various dimensions where he contributed. See, important events, aspects, and contributions with respect to Ramaswamy Naikar, or popularly known as Periyar. Now, see, he was conferred the title of Periyar. Now, Periyar means respected, or someone who is elderly, someone whose statements said are basically respected or honored. So, by the Tamil Nadu Women Conference. So, this particular organization basically conferred the title of Periyar to Ramaswamy Naikar. Now, he joined the Indian National Congress, INC, in 1919. In 1920, he was arrested because he was an active participant during the non-cooperation movement. As we move ahead, in 1921, he led an anti-liquor campaign. So, because he very well understood the consumption of liquor or alcohol is an evil for the society. So he led this campaign against and this is popularly known as the anti-liquor campaign. He emphasized and led campaigns for the representation of the depressed classes in the societies. Now, one more again, Vaikam Satyagraha, very popularly we study in the modern Indian history. From 1924 to 25, he was an active participant in this Vaikam Satyagraha. What was the basic aim of this Satyagraha? Please see. To secure the untouchables the right to use the road near the Shiva or the Mahadev temple at Vaikom in Kerala. So basically it was a movement for the rights of the scheduled caste so that they have the access to basic, let us say, usage of roads also. This was again a major step towards aspiring to have a India which was based on justice. So that is why this is very important with respect to the social movements also, and also with respect to the rights of the downtrodden or the depressed classes. As we move ahead, please see. This is very important. Chiran Devi Gurukulam case in 1925. Over here, what happened is, in this particular school, there was a segregation that was observed. The Brahmin students were made it to sit separately, and obviously the non-Brahmin students were made to sit separately, and the food was offered to them. Or they were made to sit, let us say, an isolation was created, a segregation was created. Now, Ramaswamy Periyar was completely against it and protested it. Later on, obviously, the school had to be closed because it was basically promoting the aspect of untouchability and discrimination on the basis of caste. Next is self-respect movement, 1925. Again, very important aspect over here. The aim of this movement was to uplift the Dravidians and to expose the discrimination faced by them from the upper caste. So again, this was a major role where when the word itself says self-respect, that you need to respect yourself, honor, you are equal citizens of this country. Along with it, aim was to expose the discrimination that was being faced by the various people, let us say the lower caste also. So this was a major aim was that. And Ramaswamy Naikarji basically led this also and played a very important role. Next is opposition to Hindi. Now please understand, he was against the opposition of Hindi language on the Dravidian states. He said, we also have our languages, we need to respect and honor it. We cannot simply accept the imposition of a language. That is what his aim was also. And he said that we need to respect the cultural and the linguistic diversity of India. Next is Justice Party president. Now, he was a president of the Justice Party from 1938 to 1944. Now, please understand, the goal of this party was to render the social justice to the non-Brahmin groups. Yeah, that means the people who were of the lower caste also, they had been subjected to a lot of atrocities. So justice had to be given to them and equal representation, equal participation in the society. So it was party was working towards that. And he was a president of this party from 1938 to 1944. Now, please understand one thing. Important dimension over here is that this question can be asked in your general studies paper 1 in the form of, please explain or elucidate the contribution of Ramaswamy Naikar during the freedom struggle, all during the dimension of social upliftment of the depressed or the lower class castes also. So this question can be very well asked. So it is important for you to know the contribution because it is being repeatedly mentioned in your newspapers. Now, coming to the next topic that is very, very important, because in today's newspaper, we had basically seen the topic of marital rape in the first page of the Hindu itself. What does it say? Marital relations must be exempted from the rape provision, center tells the apex court. So this is again very, very important. Supreme Court had asked the opinion from the central government. The Home Ministry basically responded with, with saying that, see, in the bond of marriage, if let us say some forceful sexual intercourse is being done by a man on his wife, in that case, there are various provisions that are present in the IPC. The center opens that you can file a case against your husband under the, let us say, Domestic Violence Act, but it cannot be treated as a rape. Now, this is what is the opinion of the central government. We will be seeing the various dimensions with respect to marital rape, what marital rape is. We are also going to see the dimensions with respect to what are the provisions in the law, what are the reports, let us say, mentioning, let us say, the Law Commission, what are the judgments that have been presented, and why this stand has been given, and what are the arguments in favor and against the criminalization of the marital rape. Right now, the criminalization of marital rape concept does not exist. For that matter, the concept of marital rape itself in our laws do not exist. Now, let us first understand, what do you mean by the concept of marital rape? See, it is an act of sexual intercourse with one spouse without their consent. Example, a man intending to have a sexual intercourse with his wife, and the wife is not ready for that sexual intercourse, that means the consent is not there, and the forceful act is being done by the husband, let us say, on the wife. Now, this is again, the reverse can also happen, but over here, predominantly, we see from the aspect that one spouse is trying to have a sexual intercourse with the other, with a spouse, without the consent of the prior. So, that is what creates an issue over here. The lack of consent is the primarily defining factor. An act needs not involve physical violence. Now, this is again the important dimension is the consent. Consent over here is the most important thing. Now, this is what is the definition. Again, repeating, that means a act of sexual intercourse with a spouse without their consent is marital rape. This provision does not exist in the Indian law. We will see why and see the dimensions associated with that. Please understand. In the Indian laws, when we see, please understand that very carefully. Section 375 of the IPC basically deals with rape, right? Now see, sexual intercourse or sexual act by a man with his own wife and his own wife, the wife not being under 18 years is not rape. Now please understand. When section 375 of the IPC defines rape, it gives an exemption. It gives an exemption on the basis of what? That sexual intercourse or sexual act by a man with his own wife. If a man is having a sexual intercourse with his wife, that case cannot be treated as a rape, provided that the wife is not under the 18 years. This was basically earlier 15 years, but changed to 18 years by the order of the Supreme Court. So what does it mean? By default, it means the concept of marital rape does not exist in the Indian laws. We will be seeing this also now. Understand why. Marital rape exception is premised on two assumptions. Please understand. Why under the section 375, why this exemption to marital rape is given? That means because husband can have a sexual intercourse with his wife, but that is not going to be treated as a rape, right? Provided the girl is more than 18 years of age, right? So why is this exemption is given? There are based on two premises. Please understand. Consent in perpetuity. Now, these are certain legal aspects you should be knowing because in your mains answer writing, you will be using them. Consent in perpetuity. What does this basically mean? Because when section 375 was there in the IPC added, it was based on certain two premises. It basically means that assume that once married, a woman gives a permanent consent. That means once a woman is married to a man, the man does not need a repeated consent for a sexual intercourse. That means a permanent consent has been given by a woman to a man. Now, this would be again considered as a archaic concept or a very old concept. That is why it is being debated over here. First assumption is consent in perpetuity, that once married, the woman gives a permanent consent to a man to have a sexual intercourse. So that means the man does not have to ask for a repeated consent for a sexual act. Second is expectation of sex. Now, why it is important? See, assumes that a woman is duty bound or obligated to fulfill sexual responsibilities in a marriage, since the aim of marriage is procreation. Now, you yourself see that Article 375 and provides these exemption to marital rape, it is based on these two premises. Second, when we are talking about obligation, that means once in marriage, it is basically the duty of a woman to provide with the sexual intercourse as a responsibility to the man, because the aim of marriage is procreation or producing children. Now, please remember, these two, if seen in today's world, can also be seen as something very orthodox, can be seen from the perspective of archaic aspect. But again, right now, this is what we have in the law. Right? This is what we have in the law. Now we will be seeing the various other dimensions also. Now, do you realize that why whenever the case of marital rape or any dimension associated with that comes to the court says that we cannot say that it is a rape as such, because the Article 375 of the IPC is based on these two premises. because it itself says that sexual intercourse act by a man with a wife is an exemption to the condition of a rape. And that is based on these two premises: consent in perpetuity and expectation of sex. That is why the concept of marital rape does not exist in India. Now, moving ahead with this, please understand. Domestic Violence Act 2005 recognized marital rape as a form of domestic violence. Now, please understand. Domestic Violence Act does recognize, let us say, a act of marital rape, but it is treated as a physical violence, not as a rape per se. That is why only provision lies for civil remedies. You cannot file a criminal complaint against your, or criminal case against your husband in the case of a rape. Over here, what we consider as marital rape is like a physical violence or a domestic violence that has been, that the woman is suffering. Not any criminal charge can be put against the man. So this is what is presented or present in the Domestic Violence Act of 2005 also. Now see, as we move ahead, let us see the judiciary and the marital rape. There have been various cases that have come up, various opinions that have been presented by the various high courts across the India. And then obviously the Supreme Court has also coined and asked, debates are going on the concept of marital rape. Let's have an overview of that. Kerala High Court in 2021 says that can be the ground for divorce. That means marital rape, what we assume is marital rape, can be a ground for divorce as a marital rape is not recognized. So what we assume is marital rape definition that we did, that can be a ground for a divorce, but it cannot be considered as a rape per se. That means that is an issue. That means because it is not recognized by law, right? Article 375 does not recognize that. Next is Karnataka High Court. Now, Karnataka High Court basically actually had a different opinion. It said marital rape, what we defined, what we understood, can be considered or brought under the category of a rape. Now, that is why we are having conflicting opinions from the various high courts. That is creating a lot of issue also. Delhi High Court, when the case went to Delhi High Court, it had a split verdict. That means one judge basically said, yes, it can be considered rape. The other judge said no. So what the outcome was, they said that matter was pushed to the Supreme Court to decide what should be done next. Now, please understand. Let us see few other commissions also, or committees also, what they have there to say. Law Commission of India 2020 said open that there is need to remove the marital rape exception. That means they want the marital rape to be criminalized or treated as something a criminal act has been done, because that exemption needs to be removed from Article 375 of the IPC. Justice Verma Commission also proposed the amendment to the rape law, where they said that criminalization of the marital rape is important. Now, as we move ahead, the article that is present in today's newspaper basically deals with the central government stand, because when the case went to the Supreme Court asked the central government what are its views on the concept of the marital rape. Now, what has the central government basically presented? The Home Ministry, on behalf of the central government, had basically presented the document telling its stand. It would, if we say the marital rape is treated as a criminal offense, or that means if marital rape is recognized also, please understand, if marital rape is recognized, then that would negatively impact the marital relationship and lead to disturbances in the institution of marriage. This is what is the stand of the central government. Marriage is distinct from the other relations, so we cannot treat marriage as an institution which is similar to other. It is a different institution, so we need to see it differently. Next is either of the spouses to have reasonable sexual access to the other. This is again based on the concept of perpetuity, where reasonable access to the sexual, let us say, access to the other partner, other spouse should be available, is again a stand. There are other provisions that can be used, but not rape. So what is the basic stand is, they say that you can use other provision, let us say Domestic Violence Act, where you can have a civil proceedings against a man, but you cannot have a rape charge against your husband in case of lack of consent, because the lack of consent concept is not existing under the Article 375, which basically states, which is based on the assumption of perpetuity, consent by perpetuity. That means once married, the woman has given a permanent consent to the husband that man can have a sexual intercourse with a woman, and women's opinion at that time, yes or no, does not matter, because marriage itself gives a permanent consent. Now, this is what is the central government stand right now. As we move ahead, please understand there are various arguments in favor and against the criminalization or acceptance of the concept of marital rape. If we see here, we'll be seeing that arguments for criminalizing the marital rape. See, the consent and autonomy. Marital rape emphasize that marriage does not imply perpetual consent to the sexual activity. Now, please understand, they say that how come marriage basically say it is perpetual consent? So there has to be some autonomy also, na? Addressing gender inequality. That means over here, it is the women who are basically suffering because men can basically misuse this because it is in favor of men, this particular law. Next is protection from the abuses. See, rape can be an extreme form of domestic violence, so it cannot simply be treated as a civil proceedings being carried out against the husband. That is again a major issue. Next is choosing legal loopholes. By criminalizing marital rape, the law recognizes that rapes is a crime regardless of the relationship between the parties. So now again, various people tend to use the loopholes in the law and misuse it against the women also. That is again a major concern. Psychological emotional aspect. Please understand that a woman who has been silently suffering because of the sexual act that is being done by her husband. Now that creates a problematic psychological emotional aspect also, which is being again raised by various NGOs and bodies. They said by simply having a civil proceeding does not justify that. Next is promoting healthy marital relationship. Now, see, this is seen as a deterrence also for man also. If you have to have a marital relationship, that should be based on equality, not favoring one gender. So this is why again one of the arguments is there. Now these were because arguments for criminalizing marital rape. Now the arguments that are against it. Cultural and religious consideration. Now see, marriage is something that is treated as a part of dharma in India. Now in that, having the aspect of criminalization with respect to marital rape can be assumed to be going against the cultural or the religious considerations. Difficulty in enforcement. Proving non-consensual sex is itself, whether it was consent was given at that time or not given. How can you prove it? If a woman says, no, I did not give the consent, but the man says, yes, the consent was given. How can you prove that? It was between two partners. It is difficult for the courts also to basically enforce because it is difficult to understand because both of them are going to give a contradictory opinion. Next is erosion of the family values. With such cases coming up, it is argued that might erode the family sanctity or which is basis of the Indian culture. Next is presumption of false accusations. Critics say that criminalizing marital rape will lead to false accusation that will be against the man. The examples that have been given is like in the case of Domestic Violence Act also. When the Domestic Violence Act 2005 came, various false accusations started rising and that became little impartial in the favor of the women. And that is what creates an issue. And that is again worried over here. If the marital rape option, let us say, is seen from the aspect of criminalization, and if marital rape is recognized and criminalized, then what will happen is that it might be misused by one of the spouses. So this is again a major concern. Next, as we move ahead, privacy and intrusion. Some opponents argue that laws do not have the right to intervene in the bedroom of the partners. How can you basically intrude and go into the bedroom, whether some act is happening or not? And this is basically going against the principle of privacy. This is also opened by various thinkers. Potential for legal abuse. Critics express that criminalizing marital rape might be misused as a weapon in contentious divorces and separation cases. When supposedly, if divorce cases is happening, in that case, they are not finding any other option. So what can be done is, the lawyers can suggest the wife to file a case against in the form of a marital rape against the husband, and that will happen again, misuse. So these issues again are there. So we need to see from a positive or a negative side both. Now, what is important for us? We have seen the complete topic of marital rape. Now, what the Supreme Court stand would be and what they're going to open is what we have to again consider and deal with when the Supreme Court pronounces a judgment on that. And this was a topic of the marital rape that we have done in totality. Next comes the obsession with the ranking is harming India's university. Please understand this is a very, very important article. What is happening is, this article basically mentions as an editorial is that we are continuously disturbed by our obsession with what is the rank of that university. Because this concept itself comes from, let us say, a United States concept where they're basically ranking their universities, and the global ranking of the universities come. And then we saw that the Indian IITs or the premier institutions were not even in the top 200s. So what we started doing is we brought our own ranking system also. Then we started working on those parameters which were like the global parameters, and we started diverting from what the aim of a university or an organization which imparts education should be. Now, over here, this article tells us that we need to understand the role of what the university should be, and it is not merely the ranking that one has to focus on. Yes, it is an important part, but not merely the ranking. Ranking itself does not denote everything what an institute stands for. Now, please understand what the article mentions. In the first paragraph, it says there is an overemphasis on the rank, overemphasis on the ranking of the institutes. We have for that national institutional ranking framework, where a lengthy process through which on various parameters, the ranking of the various government as well as the private institutions and universities is done. And on the basis of that, we decide whether some university or college is good or bad. Now again, the article is not against the ranking, but overemphasis on ranking is what is being emphasized in this article. Now please understand, when we move ahead, what is the purpose of ranking? The ranking was basically produced that we know that certain universities might be good in, let us say, one field, some in certain other field. Let us say one is good in research, some is good in, let us say, good in placement, some on some other dimension, let us say activities, or let us say research papers creation, whatever be the case. There are various fields that represents what a university or an institute stands for. So that means the purpose of ranking is to capture the multi-dimensional aspect of that organization or university. So that means capturing the multi-dimensional aspect should be the aim. But what is going on is the ranking at the global level in particular is unidimensional or one-dimensional. Why? Please understand. This editorial says that global ranking overemphasizes on the research. This one thing is the most important thing. Research, research, and research. Okay, that is an important ingredient, accepted. But it is not the most important ingredient. Other dimensions also come. That is why what is saying, these parameters, research itself as a major parameter cannot capture all the aspects. That is why he said the global ranking is one-dimensional in nature, not multi-dimensional, what is expected of a ranking system. So now when we go ahead, please understand, this article also criticizes the similar adoption by India, what the US had been doing. Overemphasis on the global ranking is something that the United States did. Privatization of, let us say, overemphasize on the privatization of institution is also again something that United States policy had been, and we have again adopted that. So what we are seeing is that the government had basically formed a higher education financing agency. Now, HEFA, what is the role of this? It uses the market resources to fund the country's aspiring institutions who want to be in the global ranking list. That means they're going to have a market money pooled in, and that would be given to those institutes who want to have a quality infrastructure or want to improve the infrastructure under various dimensions. So now, this is again an aspect which is very similar to what the United States model did. Now, what we are doing is we are focusing on ranking and market pooling in order to build certain aspects of infrastructure. Now, this is again being criticized by the article because it is neglecting the core ingredient of the institution or university, that is teaching. Teaching is what is the core ingredient. That is why all the market capitalization, all the ranking, these are basically said to be representation of what the US model of education has been, not the Indian model of education. As we move ahead, we'll be realizing that because of this system of ranking and all, what is suffering is education or the education of the children. Please understand that. Over here, when we go, he says that emphasis should be on teaching and mentoring. You realize what is going on? When the focus is completely on research so that the rank of a university can rise, then the back seat is taken by the teaching. teaching methodologies, the pedagogy, and the mentoring aspect that the teachers give to the students or the candidates. That is again a major issue being coined in this particular editorial. That is why we say importance of teaching and mentoring is what is important, because see, the global ranking basically says let us produce a number of PhDs being produced or placement being done is one of the ingredients which is taken along with the research. Now please understand, if the PhD degree is being granted because certain research has been done, again an important parameter for global ranking, over there these institutions are not PhD production companies. No, these are where actually education is being done. Is that what research is being done is actually being utilized or practical or not? Or simply the research has been done for, let us say, the purpose of getting a PhD degree. That is where the role of teaching, teachers, mentoring, and the correct pedagogy of the teachers becomes important rather than merely having a global ranking. Now, as we move ahead, we over here see that when we read this particular particle art, we see you cannot quantify teaching. See, okay, we can understand that you can rate your teachers, that this is out of 5, out of 4, whatever you rating you do. But in true sense, you cannot quantify the teaching or the teaching methodology. And that is something is not a part of your basic ranking system. In India, it has been the system where teachers, the interaction with the students, their mentoring has been there since ages. And that is what used to constitute the core concept of education in India. And now we are moving towards what? The commercial or the capital part, which is being adopted or taken from the United States. As we move ahead, see, one more thing is publish or perish approach. Publish or perish approach. That means you either produce a PhD, good enough, you go ahead, or perish. That means if you're not doing, you are taking a back seat. Please understand whether this approach, whether you're publishing some article or for the PhD also, is it of any practical value or not? Is it simply being done because the number of PhDs in country should rise, or for that purpose that the global ranking of the institute should rise, or whether that article publishing for the PhD or some research being done is of any practical value? That is what is the problem. In India, the PhD number is also rising. In United States also it's rising. But what is the difference is that the research being done is practical and being implemented by the industry, and they themselves are implementing it through the government grants. In India, what is happening is that the PhD numbers might be rising, but that research again has issues of, let us say, plagiarism, or let us say non-implementation issues. So what that creates is basically merely the number or rise in PhDs that creates a non-applicable or non-practical, let us say, thesis is being created. That again is a major problem that we face. Now, he gives 2 tracks. He said in order to resolve these issues, we need to have 2 set of faculties. One set of faculty, that means research focused faculty. That means the focus of those faculties should be that their focus is research. They would be guiding the students for research. They themselves would be researching, and that would be helping not only in boosting the environment of research, but also whatever the ranking one wants. But second set of faculties who should be solely focused with respect to teaching. Obviously, the guest lectures and exchange will happen. That is not a concern. But in that particular case, what will happen is the teaching will not suffer. But what is happening right now? Assumably, one professor is there. Because of the, let us say, pressure that the ranking of the institution or university should rise, those professors have to spend a lot of time in, let us say, research and guiding the PhD candidates. So what happens is their teaching with respect to the classrooms often suffer. Now that creates a problem because the energy is diverted between the 2 things. One is research and the teaching. Now, if we have certain specific research-based faculties who are there and others teaching, was solely focused on teaching, then that can basically resolve the issue with respect to ranking problem that is facing, and also with respect to what the teaching or the core aspect that should be the focus. This is what is the discussion that took place in this particular editorial. Now, this was the analysis of the Hindu newspaper. Hope you liked it. You understood, gained some knowledge. These are very important for your civil services examination. So please read it, understand it carefully. Newspaper reading is mandatory. You would have seen through this year's mains papers also and your prelims examination also. So all the best. Keep working hard. Keep studying. We're always there for you. The PW team is there to guide you, mentor you, and nurture you towards your goal, achieving or being capable or mentoring you or pushing you to achieve your goal of becoming a civil servant. God bless you. Take care and Jai Hind.